You can manifest it and see what happens.
We'll see. Mate, hey, we never know our luck in the mid-sized city. All right, the committee will now resume, and we are continuing with questions for the Fair Work Commission. And who would like the question?
Yeah, if I could finish
yes.
off. And look, thank you, Mr. Furlong. We did receive the email 5 to 6 last night, and it went to our general inbox, which is why we didn't see it. But I have had a look at it, and thank you for the detailed information. Very much appreciated. I have a couple of other questions before I hand over to Senator Hume in relation to CFMEU Sydney site shutdowns, and if you have any insights on those. On the 8th of May, it was reported in the media that the CFMEU shut down a major Lend-Lease site across Sydney. 3 weeks later, they shut down building sites again, the Chifley Tower, government redevelopments of the RPA, and then Nepean and Westmead hospitals. Have any of the matters relating to these shutdowns been referred to you?
No, in the normal course of things, if it relates to unlawful or unprotected industrial action, the relevant authority is the Fair Work Ombudsman.
Okay, so I'll have a chat to them about it. So I don't need to speak to you. So you don't... It will only come to you if there's a complaint about conduct on those sites in relation to employment, not in relation to the purpose of the shutdown, just so I have that...
It could come to us a number of ways. The employer could have made an application for a stop industrial action order in the event that it was occurring. So it could come through that process. It could also be dealt with by the Fair Work Ombudsman if it was considered to be unlawful industrial action. I've received some correspondence from the administrator late yesterday, and one of the documents, which I'm very happy to table as well, actually provides some information from the administration's perspective on it. There's 5 dot points here. I'm happy to go to them now if you're interested.
Look, I'm happy for you to table that. I guess the line of questioning was very much around, obviously we've seen the issues in Victoria, we've seen the inquiry in Queensland, and there are now concerns in New South Wales that those same issues are migrating there. So that is where that comes from. But if you're able to table that, that would be great.
Sure.
I'll then, I'll ask those to the Ombudsman. Very quickly, in March this year, did the Commission grant a right of entry permit to a Mr Dean Riley, the CFMEU's New South Wales coordinator? And I understand that is a permit that the Commission had previously refused.
Mr Cole has the detail on this one for you, Senator.
Thank you, Senator. I think you mentioned a March date for Mr Riley's permit matter. I think it's a much more recent decision than that. There's a decision handed down on the 27th of May, so only last week or the week before. It was a very lengthy decision by Deputy President Butler, which granted a right of entry permit to Mr Riley.
So he was granted that permit?
Yes, subject to the taking of an undertaking from the Mr Riley and from the CFMEU.
What kind of an undertaking?
Mr Riley is involved in 2 current matters that have been brought by employers, and Mr Riley and the CFMEU have undertaken to inform the Commission if any adverse findings are made against Mr Riley in those matters.
So am I right in understanding that one of the reasons for granting Mr Riley's right of entry permit relied on evidence from the new administrator, Mr Michael Crosby? And if you're able to confirm the reasons, if that's accurate, that Mr Crosby gave in support of Mr Riley's application. And I'm just mindful of the fact that Mr Geoffrey Watson, who was the author of the report that Mr Irving asked or commissioned, had concerns about Mr Riley being given that permit, and that he believed that Mr Riley would continue to break the law.
Thank you, Senator. It is correct that Mr Crosby provided evidence in support that was taken into account by the Deputy President. I'm not sure that I can do justice to the 21-page decision, which does set out his evidence in quite some detail, but he outlined his zero tolerance approach to breaches by any of his staff in relation to laws under the Fair Work Act and the Work Health and Safety Act, and that he would he accepted Mr. Riley's commitment to meet those high expectations that he has for his staff.
And I'll ask this question to the Ombudsman, but are you aware whether the Ombudsman appeared in the latest proceeding and opposed the grant of permit on the basis that they believe that Mr. Riley will break the law again?
They
despite his undertaking not to?
They took that position in that matter, yes.
They did? Okay. And you've just commented, and I just want to confirm, so that at the time of the decision to grant him the right of entry permit, supported by Mr. Crosby, 2 proceedings against Mr. Riley were on foot in the federal court, and those matters were not taken into account because final judgments had not been delivered. Is that correct?
Again, Senator, it's not appropriate for me to verbal the decision which
sets is that your understanding? Apologies.
But my understanding is that limited weight was able to be given to the matters that were currently on foot as they're untested and not a subject of an outcome in a court.
Okay. So in December of last year, when we were discussing these matters, your office confirmed to me that a removed person may nonetheless hold a right of entry permit where they retain the trust and confidence of the administrator. So I'm concerned here that we have someone where, grave concerns are held, where the Ombudsman has opposed the granting of that permit, where an individual has broken the law a number of times, but they have been granted this permit. So effectively, the administrator's trust and confidence is capable of keeping somebody on site that would otherwise be a removed person. Am I right in putting that together like that?
Senator, perhaps it's a bit hard for me to answer that question, but I think it needs to be understood in the framework of the whole of the right of entry permit system. The right of entry permit gives rights to entry holders within a framework to be able to access sites and grant limited rights in that regard to be able to hold meetings on site or to attend on site to investigate matters of compliance. If there's non-compliance with the exercise of those rights, the Fair Work Ombudsman has a role in relation to those matters, and similarly, I can imagine in the circumstances of the sorts of matters that the administrator has given by way of evidence here, that the administrator would be in a position to take disciplinary proceedings against a person who did not comply with their obligations.
So what would happen, and this is my final question, what would happen if the individual continued the conduct that they had historically shown, and the administrator didn't seek to take away the right of entry permit? What options are available to the Commission or to the Ombudsman to have that person removed?
The Fair Work Ombudsman in those circumstances would have a right to be able to apply to vary or revoke the permit on the basis of information that comes to hand.
Is there a particular additional oversight you're going to be taking in relation to this matter, given that the Ombudsman wasn't supportive of the granting of the permit?
So once the permit is issued, it is issued if the permit holder engages in any unlawful or illegal conduct. The appropriate regulator is the Fair Work Ombudsman, and they can make an application under Section 507 of the Fair Work Act to have that permit revoked or to have conditions put on that permit at that time.
So just to be clear, in that Fair Work decision, was any weight given to the fact that Riley was fined more than $48,000 for breaking industrial laws, including when a full federal court found in 2024, so 2 years ago, that he acted in open defiance of a safety requirement at Brisbane's Cross River Rail project, and the judge then called it extraordinary conduct. So I'm trying to work out how how such a change has occurred over that period of time to now grant confidence in him being able to re-enter sites.
The member who ultimately issued that permit was obviously satisfied, that the pre-qualification provisions, including the fit and proper person test, had been satisfied in these circumstances. I can't comment on the merits or otherwise of the application. The decision stands for itself.
Okay, who was that member?
Deputy President Butler.
Thank you. That's all from me. Thank you, Chair.
Thank you.
Chair, would you mind if I just... I'm going to do something that I probably might regret, but earlier today, Senator Hume indicated she wanted to ask some questions about women in construction, and the Secretary, Mr Duggan, who was at the table, quite right, said that tomorrow would be the time to ask that. And I think there may be a little bit of confusion about two organisations that have very similar names. Right. I think, I might be wrong about this, but I think Mr Duggan was referring to a group which I think is called the National Association for Women in Construction, which had received a grant from the department along with a range of other organisations about promoting the role of women in the industry. And if your questions are about that, then tomorrow would be the right time. But I know there have been media reports recently about an organisation called Women in Construction, which I think may be a different organisation.
It is.
And why I'm raising this is that I've just noticed that in one of the letters that's been tabled... Yes,
the briefing note.
The briefing note, there's a reference to that. And so, just so that we don't end up in a situation tomorrow where your questions can't be answered, I guess, depending what your questions are, we may be able to deal with some of them now.
Right.
Well,
okay.
I'm going to go to Senator
Sure.
Roberts to give you a moment to see if that's possible. So I'll come back to you after that. Senator Roberts.
Thank you, Chair. Mr. Furlong, I've got a constituent who wants to ask you a question, so I'm going to ask it for you. You probably have to take it on notice because I don't think you'll know the answer off the top of your head based on what you said earlier.
Okay.
Section 134(1) of the Fair Work Act provides, quote, "The Fair Work Commission must ensure that modern awards, together with the national employment standards, provide a fair and relevant minimum safety net of terms and conditions," end of quote. The use of the term must imposes a mandatory legal obligation on the Commission. So my question is, does the Commission have the liberty to bypass, dilute or ignore this statutory duty?
I'm happy to provide a detailed response on notice, Senator.
Thank you.
Yes, okay.
Thank you, Chair.
Are you happy for me to rotate the call, Senator Roberts?
Yes, certainly.
Okay. That was quick. Senator
Short and simple like me.
Okay, I actually wanted to follow up on some questions that I was asking the department earlier about gig economy deactivation. And specifically, since the unfair deactivation regime commenced in February last year, how many applications involving rideshare platforms had the Commission received?
Ms Eaton will be able to assist you.
Thank you.
Thank you, Senator. I can tell you that since the laws commenced, on the 31st of March, to the 31st of March 2026, we've received 541 applications for unfair deactivation. I don't have the information about how many of those relate to rideshare, although I can tell you that a very large proportion relate to Uber as a respondent.
Okay. Can I ask how many involved allegations of serious misconduct, like sexual harassment or harassment of passengers or unsafe driving?
I'll need to take that on notice.
Okay. If I could get a breakdown of each claim as to what it was that it was about, whether they are sort of fall into themes or categories, that would be helpful. So not just the ones that involve those specific things. Minister Rishworth has obviously said that the rules or the laws need bolstering, and I'm wondering if the Commission agrees that there are issues in the current regime.
That really raises a question of policy that I can't, that I'm not in a position to address. It's really a question for the department.
Okay, so if you realise that there is patterns of behaviour or continued issues with a particular cohort that you're of your clients, how do you then feed that back through to the department, who then feeds it through to the minister?
I'd like to assist,
Yeah.
Senator. We've been working collaboratively with the department over recent times to identify areas where the code may be assisted by being reviewed.
Right.
Senator, I might also add that the Commission publishes all of its decisions on the Commission's website. So if there are issues that might have been raised with the interpretation of the code and they're in published decisions, they'll be available publicly as well.
Okay, so it's not something that is collated then and fed back in any way. All right, is the Commission... Do you find yourselves essentially regulating a regime in which platforms are discouraged from deactivating potentially unsafe drivers due to the risk of reinstatement orders?
Sorry, could you repeat the question, Senator?
Yes. Do you find that you are now regulating a regime that is actively discouraging the platforms from deactivating potentially unsafe drivers because they are concerned about reinstatement orders?
I think it's, from the perspective, these cases are dealt with by members, tribunal members.
Mm-hmm.
I don't believe that we have any information available to us that could reasonably respond to that question.
All right, well, okay. I should then ask whether the government accepts that the regime may be producing unintended consequences for passenger and community safety.
Well, it's probably best if I handle that.
Yeah.
I think, as we discussed earlier, when the department were present, the Minister has requested the department to progress amendments to deal with some of these issues. So that is a recognition that some level of change is required.
Okay. Can you expand then, Minister, on what it was that the Minister was referring to when she said that the laws weren't, the platforms are not using the laws as intended?
Well, what I can say is that the Minister's asked the department to progress amendments to the Digital Labour Platform Code to establish a new process for sexual harassment matters that prioritises the safety and privacy of the complainant. The Minister's working as a priority with platforms, union and safety experts to ensure the deactivation is used as we intended in cases of sexual misconduct to protect the safety of consumers and ensure swift action is taken against predators.
Okay, all right. Can I ask some questions, please, about the road transport contractual chain orders and the process that the Fair Work Commission used to make those? Obviously, this was the first use, the recent application was the first use of the emergency road transport contractual chain order obligations and their powers. Is that correct?
Ms. Legg will be able to assist you here, Senator.
Thank you.
Firstly, so on the 20th of April, an expert panel for the road transport industry made a time-sensitive road transport contractual order, being the Road Transport Contractual Chain Order Fuel Recovery 2026. That was from an expert panel comprised of Justice Hatcher, Vice President Asbury and Vice President Gibeon, and the order took effect on the 21st of April. Mm-hmm. It is the first time-sensitive road transport contractual chain order that the Commission has made, and also the first road transport contractual chain order that the Commission has made. You've asked for some detail in terms of process, in terms of how it was made. I suppose at a high level, the making of the order followed a joint application by the TWU and the Australian Road Transport Industrial Organisation that was lodged with the Commission on the 2nd of April 2026, which sought a road transport contractual order for fuel recovery in the road transport industry. The Minister determined the application to be an emergency application on the 10th of April 2026, pursuant to their powers to do so by the Fair Work Amendment Fairer Fuel Act 2026, which took effect on the 2nd of April 2026. There was a range of consultation processes that were undertaken to make the order. That included the President issuing a statement on the 2nd of April.
Sorry, it included the what?
So the consultation processes included the President issuing a statement on the 2nd of April, which confirmed, amongst other matters, that an expert panel was constituted to consider the joint application. It confirmed initial hearing and filing dates, and a major case page for the matter was available on the Commission's website. The consultations included the panel holding 4 days of hearing, commencing on the 8th of April 2026, and one engagement conference on the 16th of April, and receiving a range of written submissions from stakeholders through the consultation process. Also on the 14th of April 2026, the expert panel issued a notice of intent and draft order by the panel for public submissions, as well as directed the Road Transport Advisory Group to provide advice on it. Public submissions are closed on the 17th of April. There were a range of businesses and their representatives, employer and employee registered organisations and owner-drivers that participated in and provided submissions to proceedings or observed the proceedings. The draft and final order were published widely, and as I mentioned, the final order was issued on the 20th of April and took effect on the 21st of April.
Okay, so essentially the order was developed, it was consulted on and then finalised within a matter of weeks.
Essentially.
What was it from go to woe?
From receiving the application on the 2nd of April and then to the making of the final order on the 20th of April.
So 18 days. Okay. What economic modelling did the Commission undertake before making the order, if any?
I'm not aware of economic modelling that the Commission undertook as part of the order.
So there's no... So the Commission, as part of this process, doesn't model impacts on inflation, on freight costs or on grocery prices?
I can't recall a specific piece of research, for example, that the Commission undertook. The decision itself speaks for itself. There was a range of considerations that were considered, which is consistent with the road transport objective that's relevant to the making of an order.
Okay. So was there any sort of cost-benefit analysis that was undertaken in the 18 days?
I can't recall a specific cost-benefit analysis that the Commission, for example, published along with the decision, but I would note that there was a range of material that was submitted by parties that was considered, and the decision speaks for itself in terms of how it considered the relevant legislative objectives that it's required to do so in the making of an order.
And what about compliance costs? Is that something that's considered as part of the process?
Yes, compliance costs, from memory, would be covered by the relevant objectives. I might see if I can bring that up in front of me. So as I mentioned, there are two objectives that need to be considered by the expert panel when making a road transport order. The first is the road transport objective, and the second being the minimum standards objective.
Sorry, the second is what?
The minimum standards objective.
Minimum
That's
standards.
found in 536JX, and the road transport objective in 40D. There are a range of objectives that need to be considered. And this includes matters such as the need to avoid, in 40D, the need to avoid adverse impacts on the sustainability, performance and competitiveness of supply chains in the national transport industry. And in relation to the minimum standards objectives, it discusses things such as the needs for standards that are fair and relevant, at 536JXC, the need to avoid unreasonable adverse impacts upon the following, including administrative and compliance costs for industry participants. That's 536JXC, Roman numerals 3.
Okay. So what evidence did the Commission rely on then to conclude that existing commercial arrangements were insufficient?
Senator, I think from there the decision needs to speak for itself. I can table the decision accompanying that, but if you'd like, I can take it on notice to outline the relevant areas of the decision, if that would assist.
Well, I'm happy for you to table the decision, but surely, considering this is the one and only one of these things that you guys have done, you probably know it.
It's just in terms of what this lady can provide you with and a response to as an independent tribunal, the decisions of the members or the expert panels or the full benches, they stand for themselves.
Yep.
And so while we do our absolute best to navigate and provide information about what's in those decisions, it's beyond us to provide analysis about the decision making behind the decision.
All right. If you could table the decision, that's fine. I'm sure I could look it up myself, but that would be okay. It's unnecessary. I want to understand, though, how many days stakeholders were given to respond to the draft order.
So as I mentioned, the draft order was issued on the 14th of April. And a public submissions process on the Commission's draft order closed at noon AEST on the 17th of April 2026.
So 2.5 days? 3 days?
I think that would be, I suppose, if you were to go 14th to the 17th. That's
What was it, close of business on the 14th, so you've got the 15th and the 16th and then half a day on the 17th?
I'm not sure at the time on which the draft order was issued whether it was the close of business.
I think it would probably make an enormous difference. I mean, it's quite a condensed time frame. If you've got businesses that need to make submissions and respond to a draft order, half a day would probably make a sort of considerable difference in such a condensed time frame.
Senator, I can only confirm the time that I've noted.
All right. Were there any industry groups that raised concerns about procedural fairness or inadequate consultation?
There were some industry associations that raised that. That's outlined in the decision.
Okay, how many?
I couldn't give you a number, but it's detailed in the decision about where those matters were raised.
All right. I don't think I'm asking too much here. Just how many industry bodies? I don't need to know what their problem was. Can you tell me how many there were?
That provided submissions.
Yeah. How many industry groups raised concerns about procedural fairness or inadequate consultation?
Senator, I would need to take it on notice
okay.
because it is a specific, it's different than asking how many people provided submissions.
In terms of the timeframes as well, on our website, it's a major case and there's a link and there's all the documentation and the timeframes associated with the case as well. So if you were of a mind to review all the submissions and the documents associated with the case, they're available.
Did the Commission consider delaying commencement to allow businesses to adjust contracts and systems?
Again, Senator, I would say that the Commission's consideration are outlined in its decision, and I can't speak further to that.
What about whether the Commission considered less interventionist alternatives before it imposed mandatory rate adjustments?
Again, Senator, apart from what's in the decision, I can't comment further.
Does the Commission accept that this order extends the Commission into commercial pricing and supply chain arrangements?
Well, the nature of road transport contractual orders is that they can set standards for road transport contractors, road transport employee-like workers and other persons that exist in a road transport contractual chain. So by virtue of the mechanism under the Act, in order to make it a chain, they can, for example, cover businesses that seek road transport services. The nature of the order, for example, will regulate contractual arrangements. But in terms of your specific question around...
Well, it's an unusual power, isn't it? And I wonder, does the Fair Work Commission have any comparable powers to intervene in a contractual arrangement, private sector contractual arrangement?
The Commission has many other functions where it sets minimum standards or price floors in relation to the modern awards system, the annual wage review decision that was handed down today. So from the perspective of setting minimum standards, the Commission is very well practised in the area.
The legislation that enabled this, the fast tracking in particular, was about the fuel crisis. Are there safeguards that exist to prevent broader future use of the emergency powers?
Might need to take that on notice.
Well, and Senator, I would note that in order to use the emergency powers, the Minister needs to make a declaration under the Act that an application that the Commission has received is an emergency declaration. So it's not...
It's not just about that. Emergency declaration isn't necessarily just about fuel. It can be about pretty much anything.
Yes, but I was responding to your question about whether the Commission can, I guess, use it at any time. It is subject to a declaration being made in relation to an application that the Commission has received.
So there aren't necessarily safeguards within the Commission to ensure that this power isn't misused?
Well, I'd say at a general level, the Commission has a range of obligations that it needs to take into account when it exercises its functions and powers. That provides the parameters for how it exercises its functions.
So what other circumstances does the Commission think that the powers could be used for?
The time-sensitive order functions, or in relation to road transport contractual chain orders?
Well, both.
Well,
the emergency powers that go with the road transport contractual chain order.
I wouldn't be able to have conjecture about how it may be used in future. As I mentioned, in relation to these powers, they are exercised when the Commission receives an application and when that a determination is made by the Minister that it is an emergency determination. It makes declares it an emergency application, and then those powers are exercised.
I suppose I should direct this question to the Minister. Minister, what does the government envisage the broader use of these powers may well be beyond fuel? Do you think that they could be used in a recession? Would that be considered an emergency? Would it be
given your
a biohazard scare?
I think that's a hypothetical on a hypothetical. I mean, you're asking me hypothetically how these could be used about a hypothetical recession.
Yeah, I'm allowed to ask you questions about hypotheticals.
And I'm allowed to not answer them because they're hypotheticals.
Well, actually, no, you're allowed to answer them. But this is legislation that you guys requested, and you not only requested it, but you didn't just limit it to fuel crisis, even though that was the premise of the legislation. And I'm wondering if you needed to have broader powers, what you envisage those broader powers might be used for.
But to my knowledge, this was developed to deal with the issues truck drivers were experiencing regarding fuel, and I'm not aware of any other intention beyond that.
Well, there was actually an effort to amend the legislation to limit it to a fuel crisis, but the government rushed this legislation through before those amendments could be tabled.
Well, I think we recognised that truck drivers were experiencing particular pain because of the fuel price increase, and that explains why we moved quickly to pass the legislation.
Do you think that once the fuel crisis is behind us, the legislation could be amended to narrow it so that it isn't
now
just a broad power?
Now you're asking me for an opinion, and I can't answer that either.
You can if
well,
you put your mind to it.
I'm choosing not to. because, as you know, questions of opinion are not in order, I believe, Chair.
Hypotheticals are, though.
Minister, you are allowed to give an opinion.
Okay,
Senator
I'll allow
Hume
that
is allowed to ask a hypothetical, but no one is able to instruct you, Minister, on how you answer any of those questions.
Yeah.
So,
I'm happy to take it on notice, Senator Hume.
That's not very helpful when we're asking for an opinion.
I'm
How much
trying
do
to give you an
think
answer.
about it? Okay. I have some more questions, Chair, but if you would like to rotate the call, you're more than welcome.
no one else is seeking the call.
Sure. Oh, okay. All right. Thank you. I want to ask about Minister's favourite subject, the right to disconnect. Obviously, that right has now
You're
been
right,
operating.
I do like it. It's more of a favourite to me than it is to certain other people.
Well, you've got an opinion on that.
I definitely have
the
an
right
opinion that
has
I
now
support
been
the right to
operating for
disconnect.
large employers since August 2024 and small employers since August 2025. Just want to understand how many dispute applications has the Commission received in total?
Ms. Eaton?
Yes, thank you, Senator. The Commission has received 17 applications to deal with a dispute about the right to disconnect since the 26th of August until the 31st of March.
17. Okay. And how many were brought by employees versus employers?
Ooh, I don't have that information before me. I might need to take that on notice, Senator.
Okay. How many resulted in a Commission order and how many were withdrawn, settled or dismissed?
I can tell you, for the 10 applications that have been received this financial year, I can tell you that 3 of those applications were discontinued before the first listing, 4 applications were withdrawn, 1 dispute was resolved through member conference and 2 matters are still ongoing with the outcome pending.
Okay. And has the Commission issued any decision around sort of giving practical guidance on when a refusal is reasonable or unreasonable?
The Commission hasn't yet issued guidance. We do have information materials on our website. We haven't issued formal guidance under legislation at this point in time. A decision was made to defer development or consideration of that guidance until there was more case law that has developed. There haven't yet been any decisions made under these provisions. Okay. And so really giving more time for the jurisdiction to develop.
It's a bit chicken and egg, isn't it, to some extent? I mean, the Commission decided not to issue guidelines due to lack of case law, but because there's no guidance, there's no cases, and potentially fewer cases are coming forward because people don't know what it is that they're, what the limitations are.
Is actually occurring is that these issues are being resolved in the workplace between employers and employees, and the very few applications are resulting to the Commission because they are being worked through at the workplace.
These issues are being resolved between employers and employees?
Yes, that's what I'm saying.
That sounds familiar, doesn't it, Minister?
Well, and in terms of, and we've published information, educational material, and I know the Fair Work Ombudsman has as well. So it's in essence, there are materials that can be relied on to inform or assist those conversations at the workplace.
Okay. Can I ask if the number of applications has increased since small businesses have entered the scheme?
I don't have so that the small businesses or employees, small businesses came under these provisions from the 26th of August last year. I think all that I can tell you at this point is that we've had 10 applications in the last financial year, so from July to the 31st of March. Okay. We've received another 7 applications before that, so I don't. There's not much to take from that as to whether or not there's been a significant difference in small businesses.
So how do you know if the right is working if there is such a low number of disputes?
I think that the Commission's role in relation to these matters is to deal with the disputes as they receive them, with the individual disputes. And so members will deal with those disputes as they arise. Whether or
Okay.
not the legislation's working as intended is probably really a matter of policy.
Can you tell me then, perhaps, how many of the right to disconnect matters have involved general protections or adverse action claims?
I would need to take that on notice.
Okay. And has the Commission identified any industries or a particular size of employer where the disputes are more common?
I don't have that information before me. I'd need to take that on notice as well.
And given the paucity of cases, it'll
Yeah.
be very difficult to get any.
I know it's hard to form a pattern when there are so few. All right. The Commission has inserted the model term into all modern awards, but delayed reviewing it. So what evidence would trigger an earlier review?
Ask Ms Leggett to come back to the table on this one. Thank you, Senator.
Senator, thank you for your question. I would just refer to the full bench statement that was issued on the 21st of November, which went to, I think, your question, and in which, at paragraph 9, it outlined, as the Commission has not yet considered any test cases nor resolved any significant disputes regarding the substantive right to disconnect provisions in the Fair Work Act, FW Act, we accept that a review at this time would have little to no utility. We think the appropriate course is to revisit whether a review should be conducted in about 12 months' time. We consider that the provision of guidelines at this time would also be lacking in utility for the same reasons. The Commission may be in a better position to develop guidelines concurrently with a review if and when that occurs. So I think from that paragraph, Senator, you can take that the consideration is around 12 months' time and that it would be concurrent with the review of the term.
Okay. It's bizarre. It sounds to me that without guidelines, without significant test cases, with very few formal applications, the right to disconnect is operating more as a political slogan than a practical workplace right.
Well, can I challenge that, Senator? I don't know whether you saw this in the Closing Loopholes Review report, but I'll just quote one section on the right to disconnect from the reviewer. At this early stage, the measure appears to be supporting a cultural shift and positive behavioural change in workplaces and has driven more conversations about appropriate contact outside working hours. Evidence provided with the review suggests the measure has supported improvements in workplace outcomes. Research undertaken by the Australian HR Institute found that 58% of employers reported that the measure had either significantly or somewhat increased employee engagement and productivity. Employers reported improvements in work-life balance and stress levels, and nearly half indicated improved management of urgent or time-sensitive matters outside standard working hours. Unions highlighted that the inclusion of the right to disconnect in legislation resulted in more bespoke enterprise agreement clauses and more constructive discussions during bargaining. So even employers are finding that this measure has significantly or somewhat increased employee engagement and productivity.
And productivity.
Well, the rationale being employees who get to clock off without having to field unnecessary emails and phone calls and get to rest turn out to be more productive when they show up to work the next day.
Can I ask that evidence, how many employers gave evidence in that?
Well, that's I was quoting from the review,
Yeah.
which itself was quoting from research undertaken by the Australian HR Institute, which I'm not aware is a union front. I think they're quite an independent organisation. So I presume that research can be easily obtained.
Okay, we'll have a look at that research. Thank you, Minister. Thank you, Chair. I do have some more questions. I've got some questions on the suburban rail loop, but I think that I will put those on notice for the sake of time. But I do want to follow up on the women in construction question, which actually I don't think was asked by me, Minister. I think it was asked by Senator Mackenzie. But that's okay.
Okay.
I wanted to understand from where the department first became aware of the allegations concerning the labour hire firm Women in Construction.
I've put Mr Manning at a disadvantage because I think he's the only person
I think he might
here from
be.
the
I
department.
thought we
But
might have taken that on notice early. If we didn't, I might take it on notice now. I'm certainly aware of recent media
Right.
reporting in relation to it, but I'll have to take on notice to see if any of my colleagues knew about it earlier. So.
Right. Okay. All right. That will do me. Thank you, Chair.
Thank you. We're now due to move to the Office of the Fair Work Ombudsman. So we might just suspend for a moment whilst we bring them to the table. But Mr Furlong, you and your officers are now dismissed. Thank you. Committee will now resume, and I call officers from the Office of the Fair Work Ombudsman, including the Ombudsman herself, Ms Anna Booth. Welcome to you. Ms Booth, do you have an opening statement?
I don't on this occasion, Senator Smith, no. Thank you for
Great.
asking.
Love to hear it. So, Senators, I'm going to start the call with Senator O'Sullivan, then I'll come to you, Senator Roberts, and we'll rotate as such. Given there's a number of us seeking to ask questions, we'll ask you to rotate the call within 15 minutes, please. I'll give you a reminder if I need to, but if you could observe, that would be appreciated. Senator O'Sullivan.
Well, thank you, Chair. I've only got a few questions, so I'm sure I'll be within that allotted time. Thank you for your appearance before us today. I want to ask about the Strategic Fleet Task Force report, in particular recommendation 7, which was to increase the Ombudsman's compliance activities relating to the payment of wages on foreign vessels engaged in coastal trading. So, can I ask how much additional resourcing has been provided to the FLO to undertake additional compliance activities relating to the payment of wages on foreign vessels engaged in coastal trading?
Thanks for the question, Senator. Yes, I think you're probably aware that there's been a pilot program that the FLO was funded to undertake for 2 years, and Mr Campbell, who has that area in his jurisdiction, will give us more detail.
And when did that start then?
We've just, I believe, exhausted the 2 years, so it must have been 2 years ago. Is that right, Mr Campbell?
That's right. So Senator Michael Campbell, Group Manager Operations, the 24-25 budget included $1.9 million in it for a 2-year pilot, which involved the compliance monitoring program. Under that pilot, we agreed, it was decided that we'd conduct 40 investigations over the period of that pilot to assist, as you've pointed out, recovery of wages for those crew members. And I can advise that we recovered $913,728 for 211 crew members as at 30 April of this year.
Okay, a couple of things from that. How much, what resourcing was provided for that?
It was the $1.9 million.
Oh, that was the 1.9,
yeah.
Beg pardon, okay. And that was for 2 years. Is it going to be ongoing?
I believe it's a terminating measure.
It was, Senator. I don't have the answer to that question. There was discussion about it, Senator, at a government level. I just don't know where that's landed.
Right. Minister, can you shed any light on that or come back to us on notice?
I'll take that on notice, yeah.
Have you, through that work, have you done any calculation or have you estimated the annual amount paid out to foreign seafarers under the Schedule A arrangement in aggregate?
Well, no, I can only talk to the recoveries that we secured, which was the 913,000.
So you haven't got any awareness or visibility to the total aggregate amount across all vessels?
Do you mean recovered outside of as in where others have sought to recover money as well?
Yeah, so the annual amount paid out to foreign seafarers under Schedule A arrangements.
I don't know that, Senator. That might be something that infrastructure might be able to assist with, but no. I mean, our role is simply to ensure that the Fair Work Act and instruments are enforced where they apply to foreign crew members, and in designing and executing our investigations, that's where we find that deficiency, and that's where we seek to recover the wages.
So from those compliance activities that you've undertaken, are you able to provide us any data on the average uplift in seafarers' wages when a seafarer's wages is when they were entitled to the Schedule A wage top-up?
So Senator, no, only because it's not within our jurisdiction or, I suppose, remit to record that. As if the minimum wage applies to the workers and they should be paid in accordance with it, we wouldn't do an assessment of the difference. Other than for the sake of determining that the minimum entitlement was paid.
Okay. Is this the only case in the entire Fair Work Act where the Fair Work Ombudsman is being obliged to monitor the compliance of payments to foreigners who have not even set foot on Australian soil?
So I suppose, Senator, we provide support for a range of different government measures and have for a long period of time.
That's not answering my question.
Sorry? Well, no, because, I mean, the fact that they're on water doesn't make a difference. You know, people can still be entitled to the benefits of the industrial relations system just because they're on water. The difference then becomes to the nature of their trading while they're in Australian waters. And in these instances, the issues go to people that should have otherwise been paid their minimum entitlements, and they weren't. It's not that a new jurisdiction's been slapped on top of them. It's just simply that they were underpaid.
These are foreign workers working on foreign vessels.
Correct, in a certain type of trade in the country.
But
there are other examples, plenty, where foreign flag ships operate in Australian waters and they're paid the entitlement they're owed in the country of origin, or whichever country they're engaged by, which would be far below Australian standards. So, I don't know, it's just the nature of the jurisdiction.
Airlines, is that another example?
I'm a bit rusty on airline, on how the Fair Work Act applies to airlines. There's other people that know better than I. But again, it wasn't, in this case, relevant.
Right. Well, if you could just come back to us for your awareness. I mean, I think your testimony was no, that you're not aware of any other example under the Fair Work Act where FO has been obliged to monitor the compliance of payments to foreigners who've not set foot on Australian soil. But if you want to confirm that and come back to me.
I'll do my best to provide an answer or notice, Senator.
Okay. Thank you.
Thank you. There's quite a number of senators seeking the call, so I'll just give an indication of order. So I'm coming to Senator Roberts, then Senator De Lega, then I'll go to you, Senator Pocock, and then I'll come to the opposition for the remainder of your time. So Senator Roberts, you've got the call.
Thank you, Chair. Thank you for appearing again, Ms Booth.
Thank you, Senator Roberts.
Would you agree that as a matter of principle and community expectation that no worker in Australia should be paid less than that required under a relevant award that applies to the worker?
What I would say is that all workers in Australia should be paid their legal entitlements.
Mr Furlong had no trouble in confirming what I just said. Twice. Are you familiar, Ms Booth, with the 2016 case where the Fair Work Commission found that an enterprise agreement between the Shop, Distributive and Allied Employees Association and Coles was invalid because the enterprise agreement paid below the award?
I'm not personally familiar with that case, but we can take questions on notice about it and its relevance to the FWO activities if you wish.
Thank you. Would you agree that this ruling of the SDA sets a clear legal precedent that any enterprise agreement that pays below the award, even when the Fair Work Commission endorses such an enterprise agreement, is invalid?
Well, since I'm not familiar with the case, I wouldn't comment on it. Ms Volsky might be familiar with it and might be able to give you further insight.
Rachel Volsky, Chief Counsel. I think we've discussed at previous Senate estimates hearings that the Fair Work Commission applies the better off overall test, so the boot test, in determining whether or not an agreement can be approved, and so long as it passes that test, then that agreement will be approved.
So I'll ask it again, Ms Volsky. Would you agree that this ruling sets a clear precedent that any enterprise agreement that pays below the award doesn't meet the boot test, even when the Fair Work Commission endorses it, is invalid?
So, and Senator, at previous estimates, we've also spoken about the mechanisms for that might be available to an aggrieved party if they wish to seek to set aside an enterprise agreement, and that would usually be one of the parties who's been made, who's a party to that agreement.
I noticed that you didn't agree or disagree. I've repeatedly raised with the Fair Work Ombudsman the situation of casually engaged coal workers subject to the Black Coal Mining Industry Award being paid less than a casualised award rate when employed by labour hire companies utilising enterprise agreements. We've previously discussed that a quantity of cases with specific details have been referred to the Fair Work Ombudsman and which the Fair Work Ombudsman has investigated. Can you tell me how many individual investigations have been completed?
As you know, Senator Roberts, a number of investigations are underway, and Mr Ronson is in charge of that, and we'll ask Mr Ronson to come up and give you a report on our progress.
While Mr Ronson is coming up, Senator Roberts, you are absolutely right that you have raised these issues a number of times at estimates, and every time I've reminded you that the One Nation Party voted against our same job, same pay laws, which were designed to fix this problem.
Because those laws were designed to cover up this problem.
No, they weren't.
They were designed to cover up, and that's what we mentioned it at the time, Senator Watt, in the Senate. That's why.
Can you point to me the section of the Act that covers up this?
This is a debate for another time. Okay, Mr Ronson.
Yeah, Steve Ronson, Executive Director, Operations, Fair Work Ombudsman. Senator, what I can confirm is that in our black coal mining investigation, we're about 2/3 of the way through. So we're in the home stretch. But the figures I can give you is that since we commenced this activity, we've investigated 56 cases and we've finalised 35. And since I last provided evidence to this committee, we have received 6 new cases. We finalised 18 cases since our last update. More importantly, and I think this is relevant to the particular cohort of workers you've been interested in, we've now issued preliminary finding letters to all the workers represented by the Independent Workers Union of Australia. So they've got all our preliminary findings where they've been given an opportunity to review those letters, review those findings, and if they have any additional or new evidence, or they disagree or confirm the findings, they have an opportunity to make submissions to us, as do the other parties.
So that's the appeal mechanism?
Yeah, well, that's in terms of they've got an opportunity to say, you've got this right, or you've got this wrong, or we agree with you, or you've missed that. But these are at quite an advanced stage, and so we're confident that within the next month or two, we should have finalised nearly all investigations.
Thank you. So what's the total number of complaints you've received? Total number still outstanding? So
there's 21 cases outstanding, but we've in total, in the last, since we began this project, this if you like activity, discrete activity, 56 cases, 56 investigations, 35 finalised.
Plus 6 new?
Since I last gave evidence, there's been 6 new ones, but we haven't had a new case since February.
Thank you. I've received feedback on a number of completed Fair Work Ombudsman investigations from coal miners that have been affected. The Fair Work Ombudsman seems to be consistent in saying, quote, as the Fair Work Ombudsman has determined that named person, terms and conditions are governed by the named labour hire enterprise agreement, we do not consider that the Black Coal Mining Industry Award 2010 applied to the person named.
Yeah.
And consequently, this is quote, named person's wages and entitlements during the relevant period should not be derived from the award, but rather the named labour hire enterprise agreement. In light of the rulings in relation to the SDA case of 2016 and the Fair Work Commission General Manager, why does the Fair Work Ombudsman now take the view that paying a worker less than the award is justifiable if the worker is being paid under a certified EA? On what legal basis does the Fair Work Ombudsman justify this?
Senator Roberts, I think you're going to hear from Ms Volsky again, and it will traverse the same topic, and that is the legal framework within which we operate, and our job is to assess whether or not that framework has been breached. But perhaps Ms Volsky will elaborate again for you.
Senator, I can't talk to all of those outcomes of those investigations, but thematically, a lot of those historical complaints also, we took the approach of assessing the situation where the agreement might apply, but which was our view, but also in the event that the agreement didn't apply, we also looked at the situation if the underlying award might be relevant. And in that case, as we've spoken about in previous estimate hearings, it's not necessarily the case that the legal consequences can be unclear as to whether or not that particular employee might have received an underpayment under the award anyway. That's because, as you know, the Black Coal Mining Award doesn't provide for casual employees in operational roles.
There are a number of things there I'm going to come back to. In relation to the actual comparing of paid rates, one assessment I've seen by the Fair Work Ombudsman compares full-time rates under the award with casual rates under the enterprise agreement. The data provided by the Fair Work Ombudsman quotes the following rates and labels. Contract rate per hour, $46.50. What's the contract rate per hour?
So in those findings, what that will mean is the payment that the employee would have received. So this would be a contract rate under a common law contract of employment. So in that situation, you've got your common law contract of employment, but then there are also minimum entitlements in this country informed by either an award or an enterprise agreement. But that contract rate would have been the rate that employee received.
Sure.
Yeah.
Okay. The award minimum rate, $21.97. These are your classifications.
Yeah, that would have either been a relevant agreement rate.
This is award minimum rate.
Or an award rate. It depends what at the time. So this could be back in 2017, 2018. Some of these cases have gone back years.
Enterprise Bargaining Agreement 2012 minimum rate, $23.10.
Again, that would have been the lawful minimum entitlement at that time in that particular situation for that worker.
So these are your figures again. Named Enterprise Bargaining Agreement 2012, casual rate, $28.88.
That's right. So what Ms Volsky's been explaining is that the peculiarity of this whole sector is that enterprise agreements provide for casual rates because it's been approved by the Fair Work Commission, but the Black Coal Award doesn't provide for casual production employees. This is the whole peculiarity of this sector.
So these quoted rates omit important information and should in fact read as follows, in our opinion, based on the rates easily accessible under the award. Your award minimum rate should be the award minimum rate without entitlements. It's the same figure, $21.97.
Because I'm just presuming that in that particular case, therefore, because there's no casual provision in the award, we're at a loss. We can't confect one where there is no such thing. This is the very odd nature. So we're reliant upon that contractual rate that they received.
So the award has a rate plus entitlements, and what you're doing is forgetting the entitlements and just taking the rate. Even though the casuals should be paid loading for all of those entitlements.
No, I would imagine in those cases there'd be an enterprise agreement that would be at play.
Because the award provides for the full-time rate, but the casual rate isn't derived from the award. It can be the agreement, but also potentially, if there is no agreement, it may well be that those particular employees are actually awarded an agreement free, which would mean they would be covered by the national minimum wage.
That's the first time I've heard that one.
It's case by case. There's 56 cases. There'll be nuances and changes on each one, but typically for the cohort that has the historical complaints, it's pretty much the same. It's the same issue that you've been advocating for, agitating for some time.
So let me add another one. Award notional casualised rate. That comes to $50.01. Remember that figure. Then where you've got named EBA 2012 minimum rate, we've added without entitlements. So what you're doing is you're taking a minimum rate, you're stripping away the entitlements, not even counting them. And you're saying that that's the case because, what was it, Ms Volsky?
Well, it will be either if there is an enterprise agreement that has been approved by the Fair Work Commission, then that displaces anything that might have otherwise applied in the underlying award, and then the employment is conditions are what's in the agreement. And if there is no underlying agreement, it may well be, because you cannot, I guess, extrapolate the full-time provisions in the award to casuals, because, as Mr Ronson's already said, in those production roles, there is no classification for casual employees.
So are you telling me, Ms Volsky, that if the minimum rate is the same in the award and the enterprise agreement, because there's no casual, the casual worker misses out entirely on all the other entitlements? Isn't that paying less than the enterprise agreement by a long, long, long way?
No, for an agreement to be approved by the For an agreement to be approved by the Fair Work Commission, the Fair Work Commission must be satisfied that the agreement passes the Better Off Overall test. So that will obviously depend on the particular matter and agreement that's before it. So I am only talking at a high level. I won't make any particular conclusions about specific case examples, but that is the general principle. And where the agreement has been validly approved, then the conditions of employment are derived therein.
Senator, what I can say is where the agreement's in play, and that's mostly the cases that you're aware of, what Ms Volsky's saying is the agreement knocks out the award. The agreement trumps in terms of the industrial instrument that informs the rates. But what I can tell you is that...
So the enterprise agreement, even if it's inferior to the award, trumps the award?
If it's a lawful agreement, it trumps. Yeah, it displaces the award.
It can't be lawful. We'll come back.
Okay, but what I can say is that this is one of the reasons we were very careful to set out our findings very carefully and provide the parties with opportunities to see whether we've got anything wrong. And I can confirm that we've received no evidence, significant evidence that will alter the findings that we've made. It might not be what the outcome that the employee wants, but it is the application of the law.
That is, the named casual worker should have been paid a minimum of $50.01 per hour for the period. On evidence in pay slips supplied to the Fair Work Ombudsman, the named worker was paid $39.55 per hour. That's less than your contract rate.
Correct. But
all entitlements wiped.
Depending in, I don't have that case in front of me, but if that case would have been based upon what is the minimum entitlement that applies to this worker in this period at this time at this site, and that's how we would have done the calculations and worked out whether there was a financial injury.
The named labour hire EBA rates that the Fair Work Ombudsman quotes omit requirements for entitlements and in this respect are arguably misleading as to the truth. The rate actually paid is less than the award, less than your contract rate, and less than the award notional casualised rate. How could the Fair Work Ombudsman get such basic information so wrong?
What I'm trying to say is, out of all the preliminary findings we've issued, we've had no evidence received in response from parties that would impact or alter our findings. It may not be the outcome that people want, but it is the correct application of the law in our view.
As discussed at the start of your block of question, I asked each senator to keep theirs to 15 minutes. You've now gone over that time. So
one question, then I'll have another block. Sorry, one question, then I'll hand over the call.
Yes, thank you.
And then I'd like another block. The miner supplied the Fair Work Ombudsman with all his pay slips. What period did the Fair Work Ombudsman consider in assessing the worker's complaint? 1 year or the whole period of it underpayment?
The whole period.
Thank you. I'll come back.
Thank you. Senator DeLady.
Thanks very much. Good evening, everyone. Thanks for coming along. Ms Booth, I'd like to ask about sham contracting and particularly in the road transport industry. And I'm not quite sure if you had the great pleasure of tuning into last week's infrastructure estimates, but there was quite a few outrageous claims made by the National Party that under this government that we have not been doing anything to address sham contracting. So could you explain to the committee what constitutes sham contracting? Or whichever official you might like to address to.
The territory of sham contracting is allied, of course, to the territory of misclassification. And the territory of misclassification, of course, is where a person is identified as an independent contractor when the proper application of the law would find them to be an employee. Sham contracting, there is a circumstance where there is a deliberate construction of or an assertion of an independent contractor relationship when a person who makes that assertion does not have reasonable grounds to hold that view. Now, that might not be quite the wording in the Act, but I will turn to Ms Volsky to provide the correct terminology.
I think that is a wonderful description, Ms Booth. Really, I think broadly misclassification occurs where a worker's treated as an independent contractor when properly characterised. They're actually an employee, and it can happen in the absence of intent on behalf of the purported employer or principal. And sham contracting is, I guess, a subset of that, where you're able to prove that actually, you know, there's some sort of, whether it's a misrepresentation or some sort of other intentional conduct that essentially purports to represent a relationship that really is an employment relationship as one of independent contracting.
Thanks, Ms Volsky. And how does the practice undermine workers' rights and businesses that do the right things?
Well, I guess what it does is it undermines the, the premise of a level playing field, because obviously where sham contracting does occur, that means potentially that those employees aren't being paid their lawful entitlements. So obviously the wages bill for that business will be less than what it would be for other businesses who are complying with their lawful obligations. So I guess it gives them an unfair and competitive advantage over, employers who are doing the right thing.
And Senator, the harm to the worker, of course, is that they are effectively removed from many of the protections of the Fair Work Act because of the asserted status.
100%, thank you. And under this government, we've increased the penalties significantly for employers who do engage in sham contracting. What do these changes mean for employers who undermine workers' entitlements?
So you're absolutely right. So from 1 January 2025, the maximum penalty per contravention is generally $19,800 for an individual and $99,000 for a business, and then increased again for larger businesses. And then they can also be subject to serious contraventions as well, which increases those penalty rates to $198,000 for an individual and $990,000 for a body corporate.
And can the Fair Work Ombudsman advise if it has concerns about possible sham contracting arrangements in the road transport industry, and what steps you're taking to, in recent times, to ascertain more information?
We are investigating a number of organisations in respect to that allegation. And
have you got any idea as to...
Mr Campbell is ready to give you further information, Senator.
So, Senator, we have 19 investigations into potential sham arrangements, sham contracting, misclassification underway in the road transport sector at the moment. They're all active investigations that haven't concluded. That said, we have exercised powers with respect to a number of those investigations, including the issuance of notice to produce. We've written to 45 entities of interest to inform them that we have a concern about the practice potentially within their supply chains, and that would be taking further action on those. We have issued 4 compliance notices with respect to road transport entities for potential underpayments, and we've also issued 5 infringement notices on transport companies for dodgy job ads, effectively advertising for positions below the minimum wage.
And as part of your investigations, are you going actually on site and doing inspections? How are you conducting those investigations?
Very much so, Senator. So we're exercising the full gamut of the investigative tradecraft and also our powers under the Fair Work Act. So site visits are an important part of that, particularly when you're dealing with a mobile workforce, if you like. So we need to be able to identify drivers on site to determine their working arrangements, who they're working to, and their circumstances and how that fits within the picture of sham contracting and misclassification.
Thanks for the work that you guys are doing. And I understand that Senator Sterle has been hosting some roundtables of recent times, recently in Canberra as well. I understand the Fair Work Ombudsman was party to the roundtables?
Yes, indeed, Senator. It is our practice to engage with stakeholders, and we have certainly done that.
And other agencies were there as well, Tax Office?
Correct.
Other ones you remember?
So we're very much taking a joined up approach to this issue and working across government with our key partners, including Australian Border Force, the ATO, and the National Heavy Vehicle Regulator. Between us all, we think that we can have a significant impact on some of these underlying issues.
Minister, there's a quote from Peter Anderson from the Victorian Transport Association from Big Rigs, where he'd said that our recent meetings in Canberra, led by Senator Glenn Sterle and attended by national transport leaders, underscored how deeply the issue resonates across the sector. And for the first time in many years, there is genuine alignment between industry groups, unions, policymakers and regulators. How does this compare to the previous government's approach when it comes to addressing sham contracting?
Well, as you've mentioned, Senator, this government has made a number of changes to the law to strengthen penalties for those who engage in sham contracting, and that was only necessary because the law under the previous government wasn't adequate to deal with this. So it's very encouraging to hear those sort of comments from an employer representative, in addition, of course, to the support for these changes that's come from unions and worker representatives as well. So, you know, I think it's good to see that that seems to be well accepted across the board and as protecting people's rights.
Thank you, and for the help of and for the assistance of the committee, last week I did table some articles to highlight some of the achievements of the government, and I might distribute that for consideration, Chair.
Tabling, yes, no problem. Thank you.
Thank you.
Thank you, Senator.
Okay, Senator Pocock, and then
Thank you, Chair. Thanks all for being here. I've got some questions about wage theft. And I want to go to a specific case. This is a case that has affected a number of students in Melbourne, international students, many of them are very, very vulnerable to exploitation at work, who've been victims of wage theft after being employed by a Mr Mamoon Durbas at shops in Crown Casino, shops called, as I understand it, Smorker, Gazette and Staff Shop. More than 10 such students have been brought to my attention. Initially, workers were paid appropriately and then in cash, and eventually not at all. When the businesses closed, some workers were owed more than $10,000. These workers have struggled to get help, spending over an hour on multiple occasions to reach the Fair Work Ombudsman, as one worker did not so long ago, eventually having to give up as she couldn't spare time away from her job to try and get some help. Others have reached out to the Migrant Workers Centre but haven't heard back. My first question is, why is there such a long wait time for people, very vulnerable people, trying to make a living in precarious circumstances on very low pay, for calling the Ombudsman to report wage theft, waiting all of that time just to try and speak to someone?
Senator, I don't have visibility of that particular matter, but it sounds like a very serious matter to me. As it happens, our current wait times for our info line, which is the first port of call for anyone who wants to make an inquiry, are 12 minutes. So I am surprised to hear that that particular person waited for an hour. It must have been an anomaly, and we may be looking to see whether or not we have a record at this time of that inquiry.
Presumably 12 minutes is an average.
It is an average, absolutely, but it's a very, I don't have a median figure for you, but it's a very consistent group. You know, it's unlikely to, there are not occasions on which it's suddenly an hour and then it's 3 minutes and the average is 12. It's a very consistent amount of time. Couldn't any of our, would you like to make any comment on it?
No, with respect to the average wait time, it is, for this financial year, 12 minutes 56, and that's down on last year. So there could be, I can't speak to the circumstance, Senator. I suppose what I am happy to do, though, is take the matter that you've raised either on notice or properly back to the organisation to determine what, if any, assistance we have or have not provided the impacted workers based on our knowledge of the employer. The call time is disappointing. I suppose what's more concerning is the underlying underpayments you've spoken
definitely,
of. So
I agree.
I'd probably, if I can, I'd like to address that, noting that a 50-minute wait it would have been caused by some sort of either peak in calls or some other challenge internally to be able to address that call sooner.
So if you could take that on notice and find what the record is there and whether any people are waiting for an hour at any time. In the last recent period, I would be curious to know, because it has a massive impact on a migrant worker sitting on the end of a phone.
Absolutely.
His time is very short. It's a struggle.
Yes.
What, if anything, has the Fair Work Ombudsman done to investigate Mr Durbas in specifically? Do you have any information on that?
No, Senator, and that's not something we'd have to hand at this meeting, at this appearance. It's not a matter that's known to me, but as I've said, I'll take it on notice.
So on notice, I want to give you a bit more detail.
Sure.
One constituent who these students are very keen to hear their interest surfaced here because they have peers who are suffering for this, and I have no reason to doubt the information that's been brought to me on more than one occasion, and this is from another state. One constituent who managed to reach the Ombudsman was referred to a lawyer who sent Mr Durbas a letter, so there will be documentation, requesting her outstanding wage to be paid, which he has not done. The lawyer advised this constituent there was nothing else to do besides go to court as an individual, which he was unable to do given legal costs and the time this would have taken. What else are people supposed to do when an employer refuses to pay? Why are they left with no options but to go to court themselves when wage theft is supposedly a crime?
Senator, obviously, as Mr Campbell has said, we'll need to look into that particular matter in circumstances where there is one individual, but in this circumstance it appears to me to be a pattern and a larger number of individuals. It would be unusual for us to not regard that as a significant and potentially systemic matter, in which case it would leave the front end, if you like, of our process, which is inquiries and then a request for assistance, and then treatment by dispute assistance. And then in those circumstances, in some cases where resolution is not obtainable through dispute assistance, we do advise and support individuals to go to a small claims process. But if a matter is tagged, if you like, as being serious and systemic, then it will find its way pretty quickly through a case management process to an investigation in Mr Campbell's area. And the reason for this is that we take a strategic enforcement approach, which is that we really are looking to be proactive and to put our resources into self-initiated activities in areas of high risk. We're looking to prioritise in certain sectors that are known as high risk so that we can make the maximum impact on disrupting the harm that is occurring to workers. And for that reason, not every worker who has been underpaid will receive the full investigatory treatment, but it's part of a system that we describe very carefully in a service charter that we have published. But in this case, this does sound to me like one Mr Campbell will want to look into very carefully, because where we've got a large number of people or an individual in a vulnerable group, which seems to be both these circumstances, international students, visa holders, they're an enduring priority of the Fair Work Ombudsman, this would be a case we would want to pay very close attention to.
Great. Well, if you're able to look at that, I mean, you've described a process. which wouldn't leave someone as an individual where there are a significant group of peers affected left on their own to pay their own costs and find their pathway through a tricky legal system. So I look forward to hearing exactly what's happened here. I guess what my mind goes to is one worker, a migrant worker, makes this call, sits on the phone for longer than they expect, and then finds themselves in the hands of a lawyer as an individual. They may not say, I've got 10 peers. They might just go to their peers and say, well, I got nowhere, so none of you are going to get anywhere. So I will be curious. One other element of this case is, which I want to come to, is why are third parties unable to report wage theft? These workers reached out to their local MP for assistance, but when that MP's office contacted the Fair Work Ombudsman, they were told it was only individual workers who were able to make a report. Wouldn't it be a reasonable thing and a good idea for third parties that people generally seek assistance from? Well, my office does it all the time in relation to housing, for example, such as MPs' offices or community legal centres, to be able to report wage theft, especially egregious ones like this, and directly to the Fair Work Ombudsman.
Indeed, we frequently take referrals from those agencies. I'll just account
so this is wrong. There should not have been.
Senator, I suppose the challenge, you've got me at a disadvantage. You've got information that I can't test, and I'm not going to tell you you're wrong.
Yep.
I can tell you that our investment in protecting the rights of migrant workers is an absolute priority for the organisation and has been for a long period of time. They're disproportionately represented in our litigation practice and have been for a number of years, which again is indicative of the importance and also concern we have about exploitation of migrant workers. Now, I'm not going to tell you that what you've raised is wrong, but what I want to do is have the opportunity to test it and understand it and give you an assessment in response to your question. But equally, if there's substance to an investigation that we can progress, then I will do that separately and obviously find an appropriate way to let you know that.
And there is you do not refuse to take third-party interventions on behalf of vulnerable workers?
We just spent a lot of time talking about black coal, where we've got multiple interested third parties. So I suppose if it's we don't say no to anyone telling us information. Okay. It's just
so
about.
But
it would be. We then need to work out what we can share with that person about the complaint that they've brought forward. So we wouldn't give running commentary to an MP that wrote to us about a concern about the constituent raised. Would address it with the constituent, and that's normally how these matters would be addressed. We'll take it on and seek to resolve it. In certain circumstances where the MP wants, or I shouldn't say any member of Parliament, wants to understand what's happened, then we'll say, well, the investigation's been concluded. But we can't share information about investigations with third parties where it's inappropriate for us to do so. So there's usually an assessment. But we're not looking to be secretive about what we do and don't do.
So it is factually incorrect to say that third parties can't report wage theft?
Correct.
Yes,
thank you. Okay, and if you could pursue that. Recommendation 26 from the draft Closing Loopholes Review recommends that the Minister should require the Fair Work Ombudsman to report annually on its activities relating to wage theft and civil remedies for underpayment, with the report to be published. What is the Fair Work Ombudsman's view on this recommendation?
So that, of course, is a draft recommendation.
Yes.
Ms Volsky, would you like to comment on that?
Yes. Look, Senator, obviously we put together our annual report every year, so I think it would be easy to incorporate that additional information should that form part of the final recommendations.
Great. Okay, thank you. Minister, I wanted to come to you on this issue. What's your view about the situation of these students waiting, as they say, for a long time on the phone to report theft, and when they get through finding that there's no action and find themselves on their own? Will you? What's your sense about a response to that?
Well, I think I've been listening to the evidence from the officials, and I think I'm right in saying they've undertaken to have a closer look at that. Again, I can give you a general statement of principle that we don't, of course, support any form of wage theft. We want to see those sort of allegations properly investigated. the Ombudsman has drawn my attention to the fact that that temporary visa holders made up 34% of all litigations commenced in 2024-25, despite only comprising 8% of the workforce. So I think that demonstrates, A, there's a problem when it comes to wage exploitation of temporary visa holders, and B, that is clearly a key focus for the FWO from an enforcement perspective.
The case worries me, though. Now, I'm going to be very curious and interested to hear your specifics on the case, what you're able to tell me. I think that's really important, but I think there is a systemic problem here. This suggests to me this is a sizable group of students who've taken the trouble to go to their local MP and then come to me to try and get some progress on it. They didn't get any support with the local migration centre either that they went to. Are you concerned about systemic failures and the need to do more for this group, or do you feel confident that you've got it on the go?
I'm not going to say that we can't do more, but as I've indicated, litigation on behalf of temporary visa holders is a very large component of the work of the Fair Work Ombudsman. So I don't think it could be said, and I know you're not quite saying this, but I don't think it could be said that these sorts of issues are being ignored.
Oh, I'm not saying that.
I know you're not saying that, but like that, for it to comprise just over a third of the litigations, I think demonstrates it's being taken seriously. You would be familiar, Senator, that we've dramatically strengthened a lot of the penalties around wage theft. So, as a government, we think that we're taking action, but of course, if there are individual cases or a number of cases here that need to be looked at more closely, that should definitely occur.
Can you provide any data, Ms Booth, on the use of proceedings and penalties that have been imposed since these penalties were strengthened on employers broadly, and specifically anything in relation to the employment of migrant workers and penalties that have been imposed? Like, is that penalty regime really causing a change in behaviour? Is it operating?
I'm just going to see if Mr Campbell's got some data on Ms Volsky of the nature that you've described. I've got examples, but not necessarily
So, Senator, those closing loophole changes with the increase in penalties, we're seeing that come through in our compliance notice litigations, which is to be expected because I guess it's the most simple enforcement tool, and so it's quicker, I guess, to work its way through our enforcement pipeline. But I think it will take some time for us to, and we certainly have investigations underway that would be within the ambit of those increased penalties, but they will take some time to work through. But I think some of the evidence that we provided in the wage theft inquiry was that certainly anecdotally what we're seeing is that employers are looking to take their obligations to ensure that they are doing their due diligence to ensure that their employees are paying their employees correctly. We've seen an uptick, and the way we see that, we've seen an increase in self-reports to us, as we know, where there's been underpayments as well. So, look, I think it's still early days, but we will be watching the area with interest, and certainly we'll be looking to litigate and secure other high-end enforcement outcomes in that space.
And
Senator,
what educative
last
question?
Rotate the call now. I'm conscious to give everyone a go.
Can I ask a last one?
15 minutes. Well,
no. Okay, that's fine.
Senator Hume.
Can I follow up on a couple of questions?
Yep.
You mentioned a couple of the wage theft investigations that the Fair Work Ombudsman is currently conducting. In February there was 2. Has that number changed?
Is this in relation to the criminal underpayments,
Yeah.
Senator Hume? Ms Carey is here, and this is her area, and she will have that figure.
Senator Michelle Carey, Group Manager, Regulatory Transformation. So as at today's date, there are currently 5 ongoing active operations, and we have 12 under assessment.
12 under assessment, okay, thank you. And have any matters been referred to the AFP or the Commonwealth Director of Public Prosecutions?
No.
without compromising any operational security, obviously, can the Fair Work Ombudsman characterise the sectors or the types of employers that are under criminal investigation?
Senator, the sectors in relation to all of the matters that we've assessed since the jurisdiction commenced, if you just bear with me, by sort of the ANZIC divisions cover, do you want me to list them all? Yep. Accommodation and food services, administrative and support services, agriculture, forestry and fishing, arts and recreation services, construction, contract cleaning, education and training, financial and insurance services, healthcare and social assistance, allied health services, professional, scientific and technical services, public administration and safety, rental, hiring and real estate services, retail and transport, postal and warehousing.
Okay, so pretty broad range within the 12. Okay. And what's the threshold that the Fair Work Ombudsman applies when deciding to pursue criminal rather than civil enforcement? Is there a published policy on that?
Yeah, our compliance and enforcement policy sets out our approach, Senator, both our civil investigations and the criminal investigations. For a referral to the Commonwealth DPP for a potential criminal prosecution, we obviously have to reach a criminal burden of proof, which is beyond a reasonable doubt.
Okay. Around the 29th of April this year, employees were emailed by by Finance or about the Department of Finance, from the Department of Finance, or I should say, about paid parental leave superannuation underpayments that were affecting current and former Members of Parliament staff employees. So when was the Fair Work Ombudsman first notified of this matter?
I'm going to have to ask Mr Campbell to look at his notes about that. We would characterise that as a part of the public sector entity self-reports.
Mm-hmm.
Department of Finance, Senator?
Yes.
I don't have that one.
No, I don't have that one either, Senator.
So the Department of Finance hasn't self-reported the underpayments to the Fair Work?
No, there are a range of self-reports. I just don't have any notes on that one, Senator. So they're not alone, I guess is what I'd be saying.
Right. Okay. So, sorry, were you aware that the Department of Finance had underpaid the paid parental leave superannuation underpayments? Sorry, the parental leave superannuation payments to its employees?
If the department has self-reported, the Fair Work Ombudsman may have staff who are aware, but myself and Mr Campbell do not have any briefing on that particular self-report in our preparation for this Senate estimates. Okay. All right, that has surprised me. I would have thought that that would have been a reasonably significant one, particularly for the people that are in this building. I might come back to that. I will ask instead about the NEMA underpayments. So the National Emergency Management, what's their last bit of acronym? What's NEMA? Minister? National Emergency Management Agency. Agency, that's the one. Yes, we are currently investigating that matter, and in accordance with our usual practice, it's not appropriate to say anything further to protect the integrity of the investigation. Okay, I won't ask for details, obviously, other than when you became aware of the potential payroll non-compliance and what was that triggered that awareness? I don't have the date of the self-report. I don't know whether Mr Campbell does.
Senator, we had an initial indication in December of 2025 and it's been formalised since then. Okay.
NEMA self-reported to the Ombudsman on the 24th of April. But why did self-reporting occur only after KPMG was engaged rather than when internal concerns first arose? Is that something you can help me with?
Without going into too much detail, Senator, they've obviously identified something in December and raised with us they've got a problem. They've got to then substantiate what that, to put some, I suppose, frame around that concern. That's why there was the time lag. Now, I don't know that they engaged KPMG. I'll take your word on that.
Okay. In October last year, NEMA reported one affected staff member, but by December it was 120. Now it's up to 591. Do you have any information that details what systemic failure caused such a repeated and dramatic underestimation?
Only, Senator, that it's an ongoing investigation, so we can't comment on that at this point.
Okay. Obviously, the Fair Work Ombudsman has prosecuted private businesses for underpayments described as administrative errors before, but obviously NEMA is a Commonwealth agency and it's underpaid 591 workers at least through what it also calls administrative errors. Is there a different treatment applied by the Fair Work Ombudsman to government agencies versus private employers?
No.
There is not, no. And our compliance and enforcement policy is applied equally to all employers.
So potentially NEMA then will face the same financial penalties and public compliance notices that private businesses would have received or would receive when found to have systematically underpaid workers across overtime, casual loading, meal allowances.
So the enforcement tool or the outcome is very much dependent upon the investigation, and not all investigations end with a coercive or a punitive tool. Mr. Campbell might like to comment further on that.
No, you're absolutely correct. It's going to go to the attitude of the wrongdoer, how they've sought to identify the issues, how they've engaged with the regulator, their intent, how did the underpayments occur, what efforts they put into either ensure that employees are being paid correctly in the first instance, and then obviously their remediation of the identified underpayments. Most often when we prosecute people, it's because there's been a reckless conduct that sits behind the underpayments that have occurred. So again, our compliance and enforcement policy sets out how we make the decisions around the use of our enforcement tools, including litigation, and that'll be stepped through in this process as well.
So NEMA has awarded a private advisory firm called Amintha a $330,000 taxpayer-funded contract to fix payroll errors that the agency itself has created. And I'm interested to know, would a private business be able to pass the cost of its own wage compliance failures onto someone else, or would it simply be required to fix it at its own expense?
Senator, I'm straying outside of the jurisdiction that we're responsible for, but obviously if a business has underpaid their staff and they need to invest in money to remediate those underpayments, then that's the cost that they bear for the non-compliance.
Okay. On the issue of the Department of Finance, my concern is that, my understanding is that Finance has self-reported the underpayments to you and also to the ATO for full transparency in accordance with recommended best practice. I'm astounded that there's nobody at the desk that knows anything about it. Can I just confirm that is the case?
If they've self-reported, there will be people who know about it.
There's no one at the desk that knows about the
Senator, without not dismissing the concerns, but we have a portfolio of work which is very large, and that includes Commonwealth entities. Yes. So we're not briefed on all of them all the time. And as we've said, it's an ongoing investigation, so we need to be careful on what we comment on.
Minister, is the underpayment of paid parental leave superannuation entitlements for finance employees, MOPS employees, something that you are aware of?
I wasn't personally aware of it, no.
Okay. Can I ask Mr Manning whether it was something that the department was aware of?
Not to my knowledge, Senator. I'm happy to take it on notice to see if others in the Workplace Relations Group have knowledge of it.
Okay. It's extraordinary. There were social media posts from staff about it. No one knew anything. Okay. I've got some questions for the Ombudsman specifically about a report that you have commenced a voluntary redundancy program for EL1, EL2 and SES staff. Is that correct?
Yes, that is correct, Senator. And I will ask Mr Scully to join us at the table as the program is in his jurisdiction.
Hello, Mr Scully. I want to ask you how many expressions of interest for voluntary redundancies have been received to date?
I can answer that if you'd like me to. The answer is 12.
12, okay. And how many
out of 1,000 employees.
How many does the agency expect to approve?
We didn't have a target of individuals. We had a target of cost savings.
Right.
So we didn't actually identify a number of people.
And what is the target of cost savings?
The target was $4 million.
$4 million. And will the estimated total cost of the redundancy payouts associated with the program meet that cost savings target?
It's unlikely, and for the detail, I'll need to go to Mr. Scully.
Thanks, Senator. Mark Scully, Group Manager, Corporate Engagement. So we have made offers for voluntary redundancies to 12 people, and the estimated savings per year for salaries and superannuation and associated on costs for those people is around $2.5 million.
Right. So the target was $4 million per year.
Yes.
Yes. Correct. Over the forward estimates, I'm assuming.
No, per year.
Just generally. Okay. So, what were the budget pressures that you were facing, or the funding reductions that led to the decision to commence a voluntary redundancy process?
The period of time that we're targeting is the 26-27 budget, for which our portfolio allocation is $181 million.
Right.
And how we were travelling and how we are travelling this year was looking towards having expenditure that was more than that. And so the senior leadership group decided to try to get ahead of that so that we could start 2026-27 in a way that would allow us to live within our portfolio allocation, and we judged that figure, if we were able to obtain it, would put us in that position. There are other savings measures that we're implementing, which Mr. Scully can go into in more detail if you'd like, and it's still not clear to us whether or not we will be able to start the year with a clean slate unless even more measures are taken, but we're taking it iteratively and making what we hope to be the best judgment possible on a stage-by-stage basis. Mr. Scully?
Thanks. So, Senator, we've made savings, we have achieved savings and looking to make further savings in our non-labour items. I'm not going to say they're discretionary, but there's some things that maybe we can look at that don't significantly impact on our core operations, and that can include travel, it can include contract staff, and we'll also put some additional controls around recruitment just to cast an additional lens over the need for recruitment of additional staff.
Okay. So you're reducing some senior staff. Is that going to affect your compliance and enforcement activities?
We don't believe so, Senator. The number of EL2s who are directors in our agency, I believe, is around 3, and the individual branches, we believe, will be able to absorb that without a diminution in service levels. And then the assistant directors are the balance of the 12, and their work, we believe, will be able to be appropriately distributed, and we'll be able to reprioritise effectively and continue our
So there's sorry, I didn't mean to interrupt you, forgive me. So there's an expectation that the agency won't be reducing the number of investigations, audits or prosecutions as a result of these.
That is certainly my aspiration. I'll ask Mr. Campbell, whose jurisdiction it is, to comment.
No, Senator, this won't have an impact on those outcomes or activities.
And what about, is there any chance that there could be further delays in response to the wage theft complaints?
No,
because
Senator,
of these?
as Ms Booth pointed out, we've got a workforce of over 1,000. We're talking about 12 individuals departing the organisation. We think we can manage within the envelope that we've got, and we've got the staff and capability to deliver on our obligations under the Act with that staffing profile.
Okay. How many of the 12 have more than 5 years' experience? How many have more than 10 years' experience?
Mr Scully may have that data, but otherwise we can supply it to you on notice. I don't have it at hand.
I might need to take that on notice, Senator. I know that a couple of them are longer-term employees, but I can't say that for every one of the 12 as to what their period of tenure has been.
Okay.
Senator Hume, I will need to rotate the call.
Okay. I suppose I just want to understand whether there's been any risk assessment regarding the loss of experienced personnel and whether you are expecting more than the 12 before the end of the financial year.
We're not expecting more than the 12 because we've closed the period of consideration. And in terms of risk assessment, we have a process that we have asked each of our executive directors to undertake. In fact, the risk assessment really was conducted earlier in the program when some people were declined their expression of interest. So anyone who an executive director believed they couldn't live without was declined. And each executive director is responsible for consulting with not just with the remaining members of the team and consulting not just with those people who would have the work redistributed to them, but also the wider group. And at that point, you're really beginning to see what adjustments there might be made, you know, to the allocation of activities. But it's not possible to do that in advance because you don't know who's actually going to go.
Okay, thanks. I'll come back to you. Thanks.
I think Senator Roberts is seeking the call, so Senator Kovacic. So can I ask you keep yours to 10 minutes, Senator Roberts, and then I'll return to the opposition. So Senator Roberts.
Thank you, Chair. Returning to the questioning. Ms Booth, referring to the Fair Work Ombudsman's decision to the miner, Appendix C, in this case, Clause 9, and I'll quote, "No time or wage records were available during the relevant period." From whom?
So that would be a detail in relation to a particular investigation that I wouldn't have visibility of. Mr Ronson, do you?
Yeah, so, Senator, I'm going to presume, but correct me if I'm wrong, but the probably case that you've got in front of you relates to the 14 cases represented by the Independent Workers Union Australia. 10 of those cases remain ongoing, so preliminary findings have been issued. From the looks of what you just put before, it looks like that's an attachment to the preliminary findings, which gives an opportunity for the worker and the employer to respond if there's any contradiction. Your question was time and wage records were not available. That would be from either party. So it might be in, I'm not sure what particular period or history this is, but it may be that there were no time and wage records available.
Because I'm advised that the miner supplied his pay slips and the Fair Work Ombudsman had the miner's total hours and pay and could calculate overall hourly rate. So it's not from the miner.
Okay, so if there's a concern, this is the opportunity to put this evidence to us if there's something that we've missed. So this is why we put the preliminary findings out, because just in case there's a question mark over what our findings are, we try to do our investigations to the best of our ability, to be as thorough as we can using the powers we have. But if we've missed something and the parties have evidence, please provide it to us. This is exactly why this process has been undertaken.
Thank you. Thank you. Ms Booth, were you previously a Fair Work Commission member?
Yes, I was from 2012 to 2020.
Did any of the enterprise agreement applications you approved as a member include an enterprise agreement covering casual coal miners?
Of course, I would be relying on memory. I don't recall any, and indeed, throughout my time at the Fair Work Commission, I spent a lot of time being the national practice leader of what's called the Collaborative Approaches program now, which took me out into the field. And I was relieved of the obligation to approve enterprise agreements quite early on in my time in the Commission. I couldn't tell you which year that was, but for a large part of my time in the Commission, I was was very kindly by the President relieved of that obligation. I don't recall any black coal cases, but the Fair Work Commission website still has every single decision that I have ever made under my name, and it can be examined to see whether or not any of those enterprise agreements fell within my purview.
Did you ever check the boot test
when I did approve enterprise agreements? Yes. And indeed, in the early part of my time in the Fair Work Commission, a member was required to do that personally. And then as I went on towards 2020, the administrative support was provided and a boot test report was provided to each member from the administrative staff to aid our examination of an enterprise agreement.
Thank you. I want to go to section 134(1) of the Fair Work Act, which provides, quote, "The Fair Work Commission must ensure that modern awards, together with the national employment standards, provide a fair and relevant minimum safety net of terms and conditions." End of quote. The use of the term "must" imposes, does it not, a mandatory legal obligation on the Commission?
Look, I'll say two things about that, and one might be asking Ms Volsky to comment on the provisions of the Act. I've not got it in front of me. I will be careful not to provide evidence to the committee other than from my current role as the Fair Work Ombudsman. I was happy to answer your questions about the Fair Work Commission, but of course I no longer speak for the Fair Work Commission. But what I would say about the modern award objective is that every member, and myself included, would have given consideration to all the factors that are listed in section 134. But perhaps
before you hand over to Ms Volsky, does the Commission, because you're investigating a Commission decision ultimately, does the Commission have the liberty to bypass, dilute or ignore this statutory duty? Must provide a fair and relevant minimum safety net of terms and conditions.
Well, the modern award objective applies in certain circumstances, not every dispute, not every case, but where it applies, it is my understanding that at the time I was a Fair Work Commission member, I was obliged to weigh all the factors that were in the modern award objective in any decision that I was making, but I would refrain from saying anything more about what I did in those times because my memory will be faulty and the Fair Work Commission is no longer my
I wasn't clear. I wasn't referring to your time in the Fair Work Commission. I'm referring to the Fair Work Commission decisions in this case.
Yeah, well, I think I've given you my answer.
As I understand it, the Black Coal Mining Industry Award says that production workers must be permanent workers, permanent employees. So how do you get over that condition in an enterprise agreement?
So, Senator, it doesn't provide. I haven't got the terms of the award in front of me, but it doesn't provide for those casual employment in those production roles. But you'll remember as well in closing loopholes, the same job, same pay order provisions came in that ensured that labour hire workers.
This happened well before that.
Absolutely, but what I'm saying is that anomaly, in the way that you've described it, going forward has been closed. We're talking about, in some circumstances, agreements that were approved many years ago, and as the regulator, we must apply the law as it stands at the particular point in time, and that's exactly what we're doing. And as we've spoken about previously as well, a number of these historical matters are outside our statutory timeframe for being able to prosecute them, but we are doing our very best to investigate them irrespective of that, and that's what we're undertaking to do. And Mr Ronson, has provided some details on that already, and we hope to have that wrapped up soon. But we have I'm very satisfied that we're doing the best that we can in the circumstances to apply the law to these particular cohort of employees.
I'm not.
Okay.
Whether it's been legal or negligence or deliberate, this is Australia's largest wage theft scam, and it's continuing. Australia's largest wage theft. It's widespread. We estimate around 5,000 miners are still being screwed by this. Does that bother you?
Well, Senator, as I said, the closing loopholes legislation in 2023 closed that loophole. And so going forward, that is what the law is now, but it is our statutory mandate is to apply the law as it applies at a particular point in time, and these are historical matters.
Doesn't the Fair Work Ombudsman's decision endorse the breach of Fair Work Act and what amounts to the Fair Work Commission's endorsement of Australia's largest wage theft due to collusions between union bosses and large global multinational employers, including an offshoot in Australia of the world's largest labour hire firm, Recruit Holdings?
So, Senator, as we've spoken about previously, if an agreement has been approved by the Fair Work Commission, then it is part of the legal framework that we must apply, and that is what we've done.
Senator, as I indicated at the start of your block of questioning, as we have two senators seeking the call, we're seeking to split the time, so that's the conclusion of your 10-minute block of questions.
Thanks, Chair.
Thank you. Senator Kovacic.
Thank you, Chair. I have some questions that I'll be brief on in relation to a right of entry permit for Dean Riley. Did the Fair Work Ombudsman oppose Mr Dean Riley's recent application for a right of entry permit before the Fair Work Commission?
We did, Senator.
Can you confirm that in opposing the permit, your office submitted to the Commission that Mr Riley would break the law again if he thought that was the best way to achieve the union's objectives?
I believe that was a quote from a Deputy President of the Fair Work Commission, but I'd have to go to Ms Volsky for the detail, as she's responsible for our litigation practice.
Yes, Senator, but I'll ask Ms Dennis to go to the particulars of that matter.
Thank you.
Excellent. Janine Dennis, Executive Director, Legal Compliance and Enforcement. Can I just ask you to repeat the question? Sorry.
Of course. Can you confirm that in opposing the permit, your office submitted to the Commission that Mr Riley would break the law again if he thought that was the best way to achieve the union's objectives? Is that accurate?
That's not how we would have described the application. I would say that the Fair Work Ombudsman opposed Dean Riley getting an application on the basis that we didn't find him a fit and proper person to get a permit pursuant to Section 512 of the Fair Work Act. And we did that in circumstances where he had previously been found to have contravened industrial laws in 5 separate proceedings and having a total of 10 contraventions, with total penalties of about $48,000.
Thank you. There are the contraventions in Queensland?
Yes, I believe they were.
The Commission told us earlier that Deputy President Terry Butler attached conditions to Mr Riley's permit. Conditions are often imposed to manage a risk. Your office opposed the permit outright. Do you feel that these conditions resolve the risk that's been identified?
So the position of the Fair Work Ombudsman in the proceedings was that we opposed the application, and our second position that we put in respect of the matter was seeking the imposition of conditions. Those conditions were a reporting condition. We were seeking a condition that they gave an undertaking that they would inform the Fair Work Ombudsman, the Fair Work Commission, if he breached the law again, and an undertaking was given by the CFMEU that they would do that of their own volition, so that condition didn't need to be imposed. And then there was a second revocation condition that we were seeking, which is basically if that he contravened the law in the future, that it would have an automatic effect of having a revocation, and it was determined by the Fair Work Commission that such a condition did not need to be imposed. The condition that was imposed by the Fair Work Commission related to some training in terms of right of entry relating to textile, clothing and footwear if he was going to
be trained.
That was the training, that was the imposition of the condition that was imposed.
Okay, so to understand, Deputy President Terry Butler required him to do some training to learn about how to properly operate how to correctly conduct himself when conducting a right of entry.
In relation to the textile, clothing and footwear sector, if he was going to operate in that sector.
So even with these conditions, do you think the risk is still alive in relation to him continuing his past conduct?
I would say that the Fair Work Ombudsman made a submission that he wasn't a fit and proper person, and that's the submission we stand behind, but we do understand that the Fair Work Commission formed a different view.
Okay. Okay, thank you. And you stand by that position, and the vouching of the current administrator for him doesn't change your position remains the same?
Our position was that given that he had contravened the Act on a number of occasions, that we didn't find that he was a fit and proper person, or that's the submission that we made under Section 512 of the Fair Work Act.
So, Senator, as well, though, I think the Commission gave weight to the fact that I think there were previous leadership figures within the CFMEU that perhaps may have led Mr Riley astray, and that I think there was sufficient weight being placed on the administrator and in particular Mr Crosby, providing a different way forward, and obviously we will continue to watch with interest in that space.
In 2023, your office secured federal court penalties for right of entry breaches at the Pacific Motorway project against a former Queensland official named in your own media release as Dean Riley with a slightly different spelling. Is that the same Dean Riley who now holds the New South Wales coordinator role and the permit granted in March?
That's correct, Senator.
Was that an error, or has the individual changed the spelling of their name? Do we know?
I would have to take that on notice, and I'm happy to do so. But I do understand that it is the same individual.
In the light of the Commission's grant to Mr Riley over your objection, can your office apply to the Commission to suspend or revoke Mr Riley's federal permit?
Yes, Senator, we do have standing to suspend or revoke that permit. Obviously, as I said, we would be keeping a close watching brief on Mr Riley and indeed other permit holders. It's a very active space for us in building and construction in the permit application matters. And I think, you know, he would be on notice, as the union would be, to make sure that he complies with the law going forward.
So you will let him keep the federal permit unless he contravenes the law again?
Well, Senator, given that the decision has been made by the Fair Work Commission to give him the permit, then I consider that it is appropriate for us to see how he behaves.
Okay, so yeah, just for my own understanding, can he hold a New South Wales permit while not holding a federal permit?
So, sorry, the New South... well, this is only about the federal permit.
Oh, it's only about the federal permit.
Yeah,
okay,
that's
so they're
exactly.
not separate. It's just one application.
There's state-based work health and safety permits, but we're only talking exclusively about the federal. I wasn't sure whether you could actually
segment where he could actually work. So when you give him the right of entry, it's federal.
That's right, but then so the federal applies.
Yes, it doesn't
across
apply
the board.
to where he's actually looking to work at that point in time. He can work anywhere he wants.
Yeah, but the state-based, exercising entry, but subject to, of course, whatever the union rules are about, you know, where he might exercise, you know, his role. But then there's the state-based work health and safety permits that sit underneath that.
Okay. Thank you. Thank you, Chair.
Okay. We're 3 minutes early. Or did you want to use 3 minutes? Sure, Senator Hume.
3 minutes worth of asking. Let's see how the answers go, though. I want to ask about the adoption of AI, and particularly there was a report in a Smart Company article by David Adams that suggested that the Fair Work Ombudsman was reporting and investing in an AI-enabled tool pilot. So I'd like to know what the status of that project is and whether it is being considered as a public-facing AI tool capable of answering workplace questions, workplace relations questions.
Thanks, Senator. Ms Carey is responsible for our artificial intelligence journey, and she will address that question. Would you like me to give any background to how it...
No, but Senator, that article made clear that it's something that we're obviously interested in doing, but it's subject to prioritisation and funding.
So is it a pilot program?
We haven't actually got a program on foot at the moment. It's something we're obviously looking at in terms of what investment we can make, in terms of enhancing our digital tools through the use of AI, but we don't currently have anything underway.
I think it might be appropriate for me to say that the article got somewhat ahead of our actual activities.
Right. So where are your actual activities?
Ms Carey.
So we don't currently have a pilot underway in relation to a public-facing tool that utilises artificial intelligence. We have an AI strategy in place and an AI governance framework, and our strategy is to focus on internal use first and low-risk use cases while we implement responsible use of AI. We are, of course, looking at future opportunities that AI may present in terms of how we could enhance our public-facing tools, but we do not currently have a pilot underway.
Okay. All right. I will follow up those questions with some on notice, and particularly follow them up next time.
Thank you, Senator Hume. Okay, that does conclude today's hearing. I'd like to thank all witnesses who appeared, Hansard Broadcasting and our Secretariat for their assistance, and all senators for their courtesy in the way today's hearing has been conducted. I remind senators that the committee has agreed that any written questions on notice should be lodged with the Secretariat by Friday the 12th of June 2026. The committee now stands adjourned.